Like that's what my so I think yeah.
Good morning.
Good morning.
So you guys remember how I told you that I want to recognize the fact that, you know, sometimes you're here and you're hungover and you just need to pass. I'm someone. I promise there's a reason. So, for those of you who are not aware, it's Purim. And there are 3 commandments, 3 mitzvot related to the observance of Purim, which began last night. The first commandment, wear a crazy costume. The second commandment is to attend the reading of the Megillah, which is the story of Purim. And the third one is to get so drunk that you can't distinguish between the hero and the villain of the story. And that's literally what the Talmud says. The hero is Mordecai, the villain is Haman, and we're supposed to cheer for Mordecai and boo for Haman, and the rabbis teach us that you are supposed to get so drunk that you cannot distinguish between Mordecai and Haman. So I'm telling you all of this to emphasize for you that we're all doing our best, and sometimes the best isn't very good, but we're all doing it. And so when you have an off day in this class, when you feel like you haven't met your own expectations, please be aware no one in the room is judging you, least of all me. All right, so let's get started. Ms. Duncan, can you identify for us the 3 rules or statutes that are in play in Burlington Northern?
So, like the 3 statutes that it talks about, like 551.
So what are the 3 statutes that are at issue in the case?
Okay. Statute 550-01, and then it was statute 550-22, and
Okay.
my stuff up, sorry.
Okay. Ms. Olive, what are the 3 statutes in question here?
There was the 2 state ones and the 1 federal one,
Yep.
but I don't know if that's all you're gonna get from me today. That was a long time ago for me.
Understandable. We have slowed down in the last few class meetings, and
So hold on, was it like 141? Oh, okay.
So
Yeah.
guys, I do want to pause here to point out that if you are doing what the book expects you to do, which is sitting down and writing out your answers to the DRQs, these problems do not arise because you just pull up the document in which you have written down your answers, and here it is, ready and waiting for you. So let this be, again, as with last time, I'm not picking on Ms. Olive. I am a little.
I knew it.
But this is something that has happened a lot to a lot of you, that I ask you a question and you go, and you start scrambling. And if you have done what you are expected to do, you should have an answer right in front of you. Okay, so Ms. Olive, do you have an answer for us?
For some reason, I swear it says 56 nothing, and I don't know why I put the word nothing there. I have no idea if there's an intention behind it, but no, I do not have an answer.
Okay. Yeah.
Pat, we did not put one.
Yes, Ms. Morgan,
I can answer
lay it on us.
that. So Federal Rule 30 allows federal courts to permit just damages for frivolous appeals and
Federal rule of what?
Huh?
Federal rule of what?
Civil procedure.
Is it a rule?
38.
Is it a rule of civil procedure?
Health.
Right. So these are in fact different things. Federal Rule of Civil Procedure 38. I actually don't know what that rule is. It's one that I've literally never encountered in my life. So let's see. I believe you. Right. Yes. So this is about demanding a jury trial. So yeah, it actually does matter which set of rules we're referring to. So what does Federal Rule of Appellate Procedure 38 say, Ms. Morgan?
It allows federal courts to permit just damages for frivolous appeals.
Right. So this is the appellate version of Rule 11. Okay. What are the other rules that are in play, Ms. Morgan?
And then the Alabama Rule of Appellate Procedure 38 also allows the same. It says that the appellate court may deem an appeal as frivolous and can award just damages to the appellee. And then the state statute, the 122272, mandates that state appellate courts impose a 10% penalty on appellants who obtain a stay of judgment by bond and affirming a lower court's decision without substantial modification.
Right. So for these two rules of appellate procedure, let me back up and ask sort of a background question. Ms. Morgan, do you know what a word of command is in the law?
No.
Okay, that's fine. Does anyone know what a word of command is in the law? Yes, Ms. Casey.
Isn't it determined, like it's a difference between a may and a must?
Exactly.
Yeah.
So for the rules of appellate procedure here, what is the word of command that is being used?
I summarized, I didn't find that specific word, but the difference between those two rules is that Alabama requires, there's no discretion. 10% is required in the state.
I think you're onto something, but I actually want an answer to the question I asked. So,
Sorry, I don't have.
Mr. Thompson, do you have one? You had your hand raised.
Were you looking for the
Word of command for the rules of appellate procedure that are in play here?
For the federal, it's may,
Okay. What about the state rule?
must?
Is it?
Take a guess.
Mr. Strummer? Mr. Strummer? You had your hand raised?
I said must too. In 72, it says it must also interject against any all or any other.
Am I asking about 122272? What did the question ask? Yes.
Just read it out. In civil cases, if the appellate court shall determine on motion or ex mero moto that an appeal is frivolous, it may award just damages and single or double cost to the appellate.
Right.
Those would be the two.
So, there's a little bit of a trick here in that shall is a word that is sometimes a word of command in this particular circumstance. So I think that's why you emphasized it. In this particular circumstance, it's a condition precedent. So if this happens, then, and the word of command here is, Mr. Hoover?
May.
Right. So Ms. Gleason, what does may mean when it's the word of command?
It's possible. It gives the court discretion.
Right. Okay. Now, Mr. Strummer, what's the word of command in 122272?
Must,
Which means what?
they have to mandate it.
Right. So, is it just me, or does this feel like a situation that is very close to Walker? So, give you a hint. So, Ms. Barral, does this seem like it's a situation that is close to Walker?
Yes.
Okay, so how does the court distinguish this case from Walker?
In Walker, the federal civil procedure was so broad.
How are they directly conflicted?
And one says must, and then the other one says in the section.
So what is it about the exercise of discretion here that creates a direct conflict?
Is it that the judge exercises discretion?
Well, let me maybe the question isn't sort of pointing you clearly enough, but is there a way that a judge could exercise their discretion under Rule 38 that would violate 122272?
I think so.
Okay, how would that happen? I'm sorry? I'm not trying to put you on the spot just now. I literally did not hear you.
Decide not to impose.
Right. Exactly right. Okay. This is what the court says, is that these rules cannot coexist because you cannot have complete and unfettered discretion to award damages and costs, and also a mandate to award a certain amount of damages and costs, because then you have fettered the discretion. Okay. So here's what the court, sort of the most key language, right? Whatever circumscriptive effect the mandatory affirmance penalty statute may have on the state court's exercise of discretion under Alabama's Rule 38, that rule provides no authority for defining the scope of discretion allowed under federal Rule 38. So, state of Alabama is perfectly entitled, perfectly allowed to create this conflict in rules and define a hierarchy that says, you know, thou shalt award at least 10% damages and costs on a losing appeal, and then more if you deem it frivolous, right? But the state of Alabama does not have the ability to change the federal rules of appellate procedure. And so the federal rules say the Court of Appeals has discretion. Here endeth the inquiry. Any state law that purports to limit that discretion cannot be applied by a federal court. Okay? So just to sort of to kind of wrap Burlington Northern up, right? Because Burlington Northern, we don't spend a lot of time with it. We're going to move on. To just wrap this up in a bow, right? If the state law would change how a federal rule of procedure operates, then it loses in the modified Erie analysis, right? The post-Hannah Erie analysis that says that rules of procedure stand at the top of the Erie pyramid. By the way, I will say at the end of this slide deck, because I've gone ahead and put in all of the DRQs for Gasparini, at the end of this slide deck, there is an Erie flowchart for you to use in your studies. It is not readable unless you zoom in, because it's kind of squoze to get it on a single slide. But it's there, and when I post this slide deck after we finish Erie, it will be available to you. Okay, so let's move on. And what questions do you have about Burlington Northern? Okay, yes.
So that final statement makes sense. Is there any other test or anything other than that we need to pay attention in Burlington? I mean, that seems too simple. Can I say it compared to all the other stuff?
What do I keep telling you guys? Sometimes it really is that simple, right? One of the things that, like, the thing that makes this simple is not Burlington Northern, it's Hannah. Okay. What we have, because identifying a direct conflict can sometimes be puzzling, right? We did have to kind of tease that out a little bit out of Burlington Northern. But once you have identified a direct conflict, you know what the answer is. The federal rule wins. Okay, so that's why this feels simpler than like the Walker case, because we had to, once we identified that there was no direct conflict, that the rules could coexist, then we had to do the unguided Erie analysis, and is it outcome determinative, and is it going to promote forum shopping or inequitable application, and like that, that becomes a bigger problem. But if you see, oh, these two rules cannot coexist, well, you know the answer at that point. Okay. All right. Other questions? Okay, now let's start with the bugbear. All right. So, sorry. Mr. Henninger, can you give us the proceedings below in Gasparini?
Yes, so at trial court, trial court awarded them, I think, $4,500 $1,000 in compensatory damages. We had an expert that said each, was it transparency, was worth about 300 or $1,500 each. And so the 3-day trial, the jury awarded him that. And then he moved for a new trial pursuant to Federal Rule 59. And then the Court of Appeals vacated the judgment and entered the jury's verdict.
Well, everything you said was correct, but I would like even more context. Like, what is this dispute here? Like, why are these folks in court at all?
Well, because the guy gave this company these transparencies and then they were lost.
Mhm.
And so he wants to recover for those damages.
And is liability contested?
No.
Okay, so the only issue is damages. Okay. Why is that important? Well, I will tell you why it is important for you guys and why you why I want you to draw that out, right? This makes this case so much cleaner. Okay. Clean cases where an issue is presented and it's the only issue that matters. These cases are gold for you as law students and as practicing lawyers, right? Because they clearly resolve one question. And you do not, and every time that question comes back up, you can go see Gasparini. Okay. So that's why we want you to know, right, that liability is not contested here, because it means that we don't have to argue over what the standard of care, what the duty of care was, whether there was negligence. Like, we don't have to play any of that. We're just asking, how much are these photographs worth? Okay, so Ms. Sadler, Mr. Henninger points out that the Court of Appeals has, vacates the trial court's verdict. And the reasoning that the Court of Appeals offers suggests that the verdict deviates materially from reasonable compensation. So where does that come from?
I think it comes from 5501C.
Okay. And what does that say?
It says that when a jury returns an itemized verdict, the New York Appellate Division shall determine that the warrant is excessive or inadequate if it deviates materially from what would be reasonable compensation.
Right. Okay. Absolutely right. Okay. So we can see, right, without sort of having to jump through all the hoops, we can assume that the Court of Appeals has concluded that 5501C is substantive. Because if it wasn't, they wouldn't be applying it, right? Okay. So we can also assume that there's a conflict between whatever the relevant federal law would be, because again, if there's no conflict between state and federal law, then it doesn't matter which rule. And generally, when it doesn't matter, federal courts will apply the federal rule because it's the one they know. Okay. So, with that in mind, Mr. Gonzalez, could you please identify the conflicts in question?
We're gonna have to pass time on.
Okay. Ms. Caballeros, can you identify the conflicts in question?
The first one I put that the standard is in 5501C is deviates materially, but the federal law, which is, I guess, common law, is shock the conscience standard.
Right, so there's one. Okay,
And then I put substantive law versus procedural law, so whether it's a question of facts versus a question of.
explain that one to me a little bit, please. Like,
I think because like they were going in on the case and they had an expert testify that each picture was worth $1,500. So that's where they came up with the 450,000. And so they were kind of like picking away at the, well, is this, picking away at some of the facts and the testimony instead of just.
well, I guess let me ask you this, because there seems to be in your answer this idea that the substantive procedural divide maps onto the fact law divide. So can you explain sort of how that thinking worked for you?
I don't know. This is just what I wrote down at the time, and I don't know where. I think that was the one that I was confused about, because I know that the third one I think was okay too, but I even put a question mark here by the second one. I didn't know if I had that.
Well, I don't know that I heard the third one from you. What was the third one?
That's the third one.
Okay.
Basically, it was a conflict in the procedural about how appeals are done, how the awards are reviewed, that abuse of discretion standard.
Okay, so it's the standard of review.
Yeah.
Okay, what is the state law standard of review?
I didn't write that down.
Okay, can someone help us out, Mr. Thompson?
De novo.
Okay, and Ms. Caballero, and you just said that the federal standard of review,
What do you think the state?
de novo. And Ms. Caballero, you said that the federal standard of review was what?
Abuse of discretion.
Right. So, I do want to expand on that just a little bit in that, at the time that Gasparini is decided, it's actually unsettled whether federal courts of appeals can review jury verdicts at all. There's a provision in the 7th Amendment that jury verdicts shall not be disturbed except under the principles of the common law. And so we're not entirely sure that this is something that courts of appeals can do at all, right? This is going all the way back to the Byrd standard of the essential characteristic of the federal system. But we are in agreement that if federal courts can do this, then, as Ms. Caballero points out, the standard of review has to be abuse of discretion. Can't be anything more stringent than that. Okay. But I want to poke at this second conflict that Ms. Caballeros identifies a little bit more, because I'm not convinced that the substance procedure divide maps neatly onto the fact law divide. I think that these are two different conversations. So I think that the answer to what the second conflict that's identified here is actually much simpler. Ms. Sadler, I'd like you to give us again the relevant piece of the New York state law that you read out earlier.
Yeah.
You were exactly right in what it was, so just read it out again.
Yeah, it says that when a jury returns an itemized verdict, the New York Appellate Division shall determine that an award is excessive or inadequate if it deviates materially from what would be reasonable compensation.
Okay, so in my Civ Pro class, my 1L year, we actually spent some time on additor and remediator, which is motion practice related to the appropriateness of damage awards. Did you guys do that in Civ Pro 1?
No.
Okay, that's fine. It's not a big deal. The key piece of this is that if you are asking a federal court to set aside a damages verdict because it is inappropriate, the first court you ask is the court that heard the case in the first instance, which means unless you are the state of Kansas suing the state of Missouri, it's a United States District Court. So who, according to 5501C, is the first instance reviewer of the appropriateness of damage awards? Ms. Musseter, who do you think? What does the statute say? Right, this is a question, like, you can draw this directly from the statute. Right. So this is the second conflict that the court identifies, in that if you want to do something like this in a federal court, you go to the district court. Okay. New York says you go to the appellate division. Does anybody know what the appellate division is in New York? New York uses wonky names for its court system.
Supreme Court?
No. So the Supreme Court in New York is the trial court of general jurisdiction. Okay. The court of last resort, which in Kansas is what?
Wait, sorry, Supreme Court.
Right. The court of last resort in Kansas is the Kansas Supreme Court. In New York, Mr. Roberts, what's it called? Right. The New York Court of Appeals. The New York Supreme Court Appellate Division is the intermediate court of appeals for the state of New York. So do not ask me why they used this naming structure. If I had to take a guess, I'd take a guess that it has something to do with the fact that New York was essentially a feudal fiefdom until 1845. And that's like actual history. That's not me editorializing. My guess is that all of the weird things about New York state politics sort of stem from the fact that they weren't really a democracy until the mid-19th century. Okay.
So this,
Yeah.
this is the district court determining measure of damage. That's the issue with the reexamination clause. Or that's
That is one of the three issues, right? So to recap, the three issues that the court identifies here is the standard that is applied to reviewing damages awards, right? The state court says that it is excessive if it materially deviates, whereas federal courts apply a shocks the conscience standard, which essentially means it never meets the standard. Shocks the conscience is so deferential that when the Fifth Circuit ruled that it shocks the conscience to leave a prisoner naked in a feces smeared cell with no running water for a week, it surprised people. So that's how deferential shocks the conscience is. So that's the first issue. The second issue is who decides. In the federal system, trial courts decide. New York State says the appellate division, the intermediate appeals court, decides. And finally, the standard of review, the state grants the appellate division de novo review of the damages award. Federal system, at most, applies abuse of discretion. Okay? Okay. What questions are there about this? Yeah, Mr. Van.
So just to sum up, 3 issues are regarding the standard of review between the federal and the state. The other one, because we got rid of the substantial versus procedural issue for something simpler, and that had to do with what again?
Well, we've not gotten rid of the substantive procedural divide.
No,
Right.
but I mean, for purposes of this question, is that an issue that is considered?
All of these conflicts are being examined to determine whether they are substantive or procedural, because that is the fundamental question of any Erie analysis. Is the state law substantive, in which case it should apply, or is it procedural, in which case the federal rule should apply? So does that help?
Yeah.
Okay. Mr. Stromer, did you have a question? I thought I saw your hand.
Yeah, well, I just wanted, so the reexamination clause falls under our district court, appellate court, who decides. That's correct.
I'm sorry.
On determining who decides, the issue regarding the reexamination clause was for that, correct? Not
All of these have to do with the reexamination.
so they
clause.
all fall underneath that,
Yes.
and specifically the 3 things. Okay.
Yeah.
So I can just delete.
Okay. Well, I don't know what you can and can't delete.
Well, I have a reexamination clause, but you're saying that's just like the umbrella of all the 3 issues that we talked about.
There's only one state rule at issue here, with multiple conflicts coming in. Okay. So, all right. Other questions? So, I actually, that's worth backing up and sort of expanding on just a little bit, right? In Walker and Burlington Northern, we had multiple state rules that came into play. And the question was, how did one federal rule interact with these 2, in those cases, rules? In this case, we have one rule from each system, but they butt heads in multiple ways. And so that's what makes Gasparini different. And to some extent, that's also what makes Gasparini difficult, because you're having to analyze these multiple issues and how they interlock in a way to determine what the final outcome of the Erie analysis is. Okay. So, questions before we move on? All right. Okay. Mr. Cruz, I'm going to ask you to tell us a little bit about how the dissent and the majority in Gasparini see this case, right? So, this shocks the conscience standard that they are relying on for the federal rule. Where does the majority source it from?
I wanted the first one again.
the majority, where did they source the shocks to conscience standard?
Shocks to conscience standard, I think that's.
Not as in, so I'm not asking who applies the shocks to conscience standard. I'm asking, right, this is an issue of law. Law comes from somewhere. It has to be enacted by somebody. So who enacts the shocks to conscience standard according to the majority?
I don't have that in minutes, but I assume it's in New York. Lecture.
Well, let's back up a second. Is the shocks to conscience standard the federal rule or the state rule in this case?
I'm not just the federal.
Right. So the New York legislature, whatever its faults, it is not responsible for the shocks to conscience standard in this case, right? Is there any language in the majority opinion, the pieces of it that you're given, right? Because it's excerpted. But is there any language in the majority opinion that gives us a clue as to where they think that standard comes from? Okay, Mr. Massey.
Use the language judge made law.
Right, which says what? It's common law, exactly. Okay, so Mr. Massey, let me follow up with you. If the shocks to conscience standard is common law originated, what type of Erie analysis do we do? Let me give you some choices rather than just sort of like throwing you out here on the field, right, with no guidance. Is this a Hannah case, or is this a guarantee trust Bird Walker case? Well, what is required for Hannah to come into play?
Correct. Federal rule in the state.
So can somebody help him? Because I have run out of questions. And that's on me. That's not your fault. So yes, Ms. Morgan.
I think we apply the unguided because if you're not dealing with a federal procedural law, the other, like the Hannah, that doesn't.
Right. Hannah says federal procedural rules win. And it's modified by the Walker Burlington Northern direct and indirect conflict, right? But you are correct that if there's no rule of procedure in play, then we are using the unguided Erie analysis, and we got to jump through all the hoops and do the outcome determinative. All right, so Ms. Holman, now I want to ask you about the dissent. What is the source of the shocks to conscience standard according to the dissent?
And what is
The source. Where does this come from?
is it the statute 501?
So let's return to, is the shocks to conscience standard a federal rule or the state rule in this case? Right? So where does the dissent say that comes from?
It's civil procedure.
Exactly right. And so, based on the conversation we just had, assuming you weren't on Reddit, no judgment either way. But based on the conversation we just had, does the dissent think we're in a Hannah world or a guarantee trust Bird Walker world? I'm sorry? Correct. Absolutely correct. Okay. So let me sort of follow up with one last thing. Does the dissent read the state rule and the federal rule as being in direct conflict, or do they think it can coexist?
They, is that right?
Right, that is exactly what the dissent says. And so if the dissent had carried the day, what would be the outcome? Let me walk you through what you've already told me. Okay. So once again, what is the source of the shocks to conscience standard?
The Rule 59.
Right. And can the shocks to conscience standard coexist with the materially deviate standard? Again, according to the dissent. No. Which means, which rule applies? Which is shocks. Yes, exactly right. Okay. So this is how we apply the Hanna test after Walker and Burlington Northern. Right? Identify the rule of procedure that's in play. Determine if the state rule and the federal rule can coexist. If the answer is no, the feds win. Okay? This step of the reasoning, of the logic, is actually much simpler in the majority opinion, because the majority says this comes from common law. We don't have to determine it if they're in direct conflict. We move straight on into the unguided Erie analysis. Now, what that means is that the next step is more complicated. So, all right. So, I'm going to give you guys a piece of secret knowledge. When I put these slide decks together, sometimes the title of the slide gives you hints. So, Ms. Silva, what's the first step in determining which of these two rules should apply?
I originally thought it was decide if it's substantive or procedural, but now you're like, I think I questioned that.
You're correct that that's what they're trying to do, but what do they conclude? And that's where the title is.
Says neither.
Oh, let's flip that on its head.
Says both.
It's both. Right? So why is it substantive, Ms. Silva? I heard that sigh. Why is it substantive?
I'm gonna pass. I can't put it into words.
Ms. Sadler?
I have found that it's substantive in that materially deviates materially standard controls how much of points to be awarded, and procedural in that it assigns decision-making authority to the viewer.
That's exactly right. Okay. Say it again a little louder so that you can be heard over all the keyboards clacking as people type it into their notes.
So it's substantive in that deviates materially standard controls how much a plaintiff can be awarded. And it's procedural in that it assigns decision-making authority to the New York appellate.
Right. Ms. Sadler, you are correct, right? You are absolutely correct. I'm now going to ask you a policy question, which means that this is asking for your opinion. What's the problem with that as a conclusion?
I mean, I feel like it would be hard to apply, because we've been talking about if it's substantive or procedural, what the federal court will apply, what they want.
I mean, I would go farther. I think you're right, but I would go farther. It is impossible to apply. If a rule is both substantive and procedural, then Erie does not tell us which rule should apply. Nor do any of Erie's progeny that we have studied, because they all assume that a rule is either substantive or procedural. And so in this case, where the court concludes that it is and rather than or, we are not finished. So the last thing that I want to do today, because we have about 5 minutes left, the last thing that I want to do is that question should say next, but it's the same question. What's the next step in the reasoning? So, Mr. Knapp, do you have an answer for us for what's next? Now that we've determined that the rule is both substantive and procedural. Thanks, Justice Stevens.
Originally, I thought probably wrong, but I wasn't sure if the outcome determinative test applied, because they talked about it more in the case, but wasn't sure if that was right. But
No, you're right. That's the next step, right? So if we can sort of clearly go substantive, procedural, then we can end the area of inquiry there. If we can't, as here, then we move on to whether the applying the state rule or federal rule is outcome determinative. So, Mr. Knapp, can you give us well, look, I will just, rather than like ask you to identify the beautiful language, this is what my common law professor used to say, the beautiful language in the opinion. Let me just give you sort of the relevant piece here, right? So the court says classification of a law as substantive or procedural for Erie purposes is sometimes a challenging endeavor. And then it goes on to talk about guaranteed trust, which is where the outcome determinative test comes from. A later path marking case qualifying guaranteed trust explained that the outcome determination test must not be applied mechanically to sweep in all manner of variations. Instead, its application must be guided by the twin aims of the Erie rule, Mr. Hoover.
Oh, yeah. So as we all know, the twin aims of the Erie are 1, to avoid forum shopping, and 2, to avoid the it's not, voices are helping. Hold on, the inequitable, administration of the law.
All right, great job, team. Great job, team. All right, so informed by these decisions, we address the question whether New York's deviates materially standard is outcome effective in this sense. Okay. So, everybody clear on where we are in the analysis at this point? We are in the process of applying the outcome determinative test. Okay. Here is my quorum present for you. When we finish Erie, we will not go on to begin personal jurisdiction on Thursday. So we will begin personal jurisdiction after the midterm, after spring break. So now the downside for you guys is this means that almost all of your midterm will be Erie. But we have 5 DRQs left in the Erie chapter. We will knock those out on Thursday, and then you will begin your spring break early. All right, so see you guys Thursday.
Number 63, is that just the end, then outcome determinative, and that's where we stop?
Yep. Yep, that
Wasn't
we,
anything further.
the next step is to apply the outcome determinative test.
Thank you.
All right. See you guys Thursday.
I guess.